Hi, I'm Sibyl Winchester, Counsel for Bespoke Title Holdings. This is Legal in 60 Seconds, where I break down real estate legal questions and hot topics in under a minute. Today's question is, does my spouse have to sign for my property transaction if we have a pre or post-nuptial agreement in place? In Texas, if you're selling or borrowing against your homestead, which is your primary residence, the law requires that both you and your spouse give consent, even if only one of you is listed on title. Many people assume that this is because of Texas community property rules. While those laws do play a role in some cases, the real reason your spouse often needs to sign is due to the homestead protections in the Texas Constitution. Even if your home is your separate property, your spouse must still consent to the sale or refinance if it's your homestead. Sometimes sellers bring in a prenuptial or postnuptial agreement and think that that will allow them to sell without involving their spouse. While those agreements may define who owns the property, they don't override Texas homestead laws. If the property is your homestead, your spouse still needs to join in on the transaction. Homestead and ownership laws can get complex, especially if there's a pre or postnuptial agreement in place. Specific requirements can vary. If you're unsure what applies to your situation, don't worry. That's what we're here for. Always check in with your escrow team early in the process so we can guide you every step of the way. There you have it. Let us know what you like answered next.